Welcome to the latest episode of Constantine Law's Immigration Podcast. For those who are joining us for the first time, I'm Rebecca Tester, Immigration Partner at Constantine Law, and I'm delighted to host today as we explore British citizenship. I'm joined by my colleague and fellow immigration partner, Alex Finch. Alex has a particular interest in British nationality matters and he's really highly experienced in complex citizenship and ancestry applications. So no one better to talk through this topic with us. So without further ado, Alex, I'll start off by asking you, what is it about citizenship that is interesting to you and why did we want to talk about it?
Thanks very much, Rebecca. Yeah, I do love citizenship, especially ancestry-based cases. I thought, though, an equally fascinating question to talk about today would be the question of whether to apply for citizenship at all. So, yeah, there are people who live abroad who might be able to claim citizenship and use that to facilitate a move to the UK through ancestry. But the more common scenario for the clients looking at when they are thinking about whether to apply for citizenship is whether to apply for naturalisation. So just to kind of talk about the slight basics of that. Since 1973, and I think probably before that, indefinite leave to remain, or ILR, also known as permanent residence or settled status or settlement, is the primary thing that a migrant moving to the UK would be aiming towards getting. That's the status that gives you the right to live and work in the UK without restriction indefinitely, without having to apply and pay again. And it does represent a level of security, but it's obviously less than British citizenship. So it gives some level of access to citizenship for your children. If you have ILR, if you have children already born in the UK before you get ILR, then once you've got your ILR, then they can register as British citizens until they're the age of 18. And if they're born after you get ILR, then they're born in the UK, then they're automatically British. But if they're born outside the UK after you get ILR, that doesn't do anything in terms of citizenship. So in a way, what British citizenship gets you beyond ILR is quite small. It could be seen as quite small, but for the reasons I'm going to explain or go through, I think actually they're more powerful than you might think, and there's strong reasons for going on and getting it. So that's really what I wanted to talk about on this episode. So just to kind of lay out the basics of what you get with British citizenship. If you've got ILR, it's lost if you're absent from the UK for more than 2 years in a row in the main case, or if you've got settled status under the EU settlement scheme, if you're absent for more than 5 years in a row continuously. Whereas British citizenship is never lost through absence from the UK. And so the main thing that the citizenship or naturalisation does, in a way, is to lock in what you've achieved by getting ILR. And I think that's something that different categories of people moving to the UK will feel differently. For a non-EUSS migrant, for someone who hasn't moved to the UK on the basis of the EU settlement scheme, you're going to have paid these days a huge amount of money and expended a lot of uncertainty and a lot of effort and time in getting that ILR status. Perhaps you might be paying in the region of £10,000 over a 5-year period, or possibly more, 20 or 25,000 if you're also paying for all of your family members, in terms of government fees and immigration health surcharge and other costs. And if you leave the UK and lose your status and then want to come back to the UK in the future, then you're going to have to start that whole process again. And that's a really significant thing. And it happens more often than we realise. There is circular migration between the UK and many other countries internationally, especially those close to us. And so that's a really powerful consideration. You also get a British passport. That doesn't make much difference to your civic rights within the UK, doesn't make any difference to your ability to own property or to engage in any kind of business in the UK. But it does affect your travel internationally. So the British passport is not as powerful as it used to be. It gives visa-free or visa on arrival access to 170 countries, which is one of the best ones. Still not as good as, for example, Singapore with 195 countries visa-free. But that's a very strong consideration, especially for those from countries which have less powerful passports, for example, the developing world. So the attraction of visa-free travel, as well as British consular assistance if you're abroad. Those are probably the most kind of weighty reasons. There's also the fact that if you were ever convicted of a criminal offence, there's a threshold for deportation, which is now a 12-month custodial sentence as a starting point. probably less relevant for most people. And also, if it's important to you, voting in general elections is only preserved of British citizens or, strangely, Commonwealth citizens who can start to vote in UK general elections as soon as they arrive and are legally resident, which is really strange. But those are kind of the reasons why you might want to do it. And against that, why wouldn't you want to do it? Why wouldn't you get these benefits? Well, probably the main one is the cost. So you're paying £1,839 now, £1,839 per adult and £1,000 per child to apply for British citizenship. And that's a huge profit to the Home Office. The unit cost of processing the application, which is the amount it costs the Home Office to process this application, is only £575. So they're making more than £1,000 on each application, and that basically just goes into the Home Office budget, if that feels good for you. Employing 55,000 people in the UK, these rates have inflated massively over the years. Back in 1983, it was £200 or for an application, or £70 if you're married to a British citizen. Another reason is dual nationality. So you might be from a country that doesn't allow dual nationality. For example, most countries in Asia or many countries in East Africa don't permit dual nationality. So, for example, China, India, Singapore, Japan, Germany was on that list until a couple of years ago. But you might not want to lose that citizenship because it might be a more powerful citizenship, for example, for travelling internationally, if you're Japanese, Singaporean, or there might be other reasons to do with just emotional reasons, wanting to go back there one day, maybe issues of inheritance. British citizenship, strangely, doesn't offer any enhanced family reunion rights either. So you're in the same position if you wanted to sponsor family members in the future, if you've got ILR or if you're a British citizen. So those are probably the main reasons you might not want to do it. You have to swear an oath or affirmation of allegiance to the King. Probably not a big thing for most people, but worth noting that the UK allows you to not believe in God, but you do have to promise to bear true allegiance to the King. So I think probably stop at that point. But those are the main reasons. Those sort of some of the reasons why you will want to do it, and some of the reasons why you wouldn't want to do it. So this is a sort of long way of saying, I think actually the reasons, when you delve deeper into those reasons, I think you realise that there are really good reasons for wanting to do it, and that's really what I wanted to talk about today.
Thank you, Alex. There's quite clearly several factors to weigh up before you kind of even think about making applications. I guess the next logical question, and very important one, is that what are the main requirements to naturalise if you're thinking about doing it?
Yeah, this is something that probably most people facing this question will often know, but and these requirements haven't changed, strangely, in immigration law. I think since I started practicing, almost everything has changed. Every single route has been completely reformed, other than the process for naturalisation, which is based on statute and can't change without an act of Parliament. So you need to pass the Life in the UK test and an English language test. You'll have already passed this in most cases for your ILR, but if you've got settled status under the EU settlement scheme, then you won't have got this. So you can meet the English language test by having a degree entirely taught in English or being a national specified majority English speaking country. Otherwise, you'll need to go and do a secure English language test. You need to have good character, so that's something that's applied increasingly strictly now. Any pending prosecutions will result in the application usually being paused until they're resolved, and there's very extensive disclosure requirements before you can apply. And then the big two are the residence requirement and the intentions requirement. So the residence requirement is that in the 5 years prior to applying, you can't have been absent from the UK for more than 450 days in the last 5 years and no more than 90 days in the final 12 months on the date of application. If you're over those limits, there is discretion in certain circumstances to waive those excess absences, and there's extensive guidance from the Home Office on how they will exercise that discretion. That's often something we're advising on. And the other thing is the intentions requirement. So you can't have a settled intention to emigrate from the UK at the point in time that you are applying to naturalise. You have to certify that you intend to reside in the to make your home in the UK, or if you're lucky enough to have more than one home, your principal home. Or if you intend to continue in Crown service or in service of a UK company, that's an exception to the intentions requirement. And with all of these, there's a slight if you're married to a British citizen, the residence requirements are slightly different. As the intention requirement is removed, and you're looking at a 3-year period, but similar requirements overall. So that's basically what you need to do in order to qualify.
Thank you, Alex. So really, why might you think about making an application now?
Yeah, so I think really, I talked already about the opportunity cost, the sunk costs of having already gone through this pain and cost of applying for all of the visas up until ILR, and they're very considerable. And when you step back and look at the history of immigration, or at least in my lifetime and during the time that I've been practicing, the requirements have always just got more difficult, pretty consistently, actually. So, for example, being married to a British citizen or to a person born in the UK, before 1949, that meant you were automatically a UK citizen, UK national. Before 1983, it was an automatic registration. If you were married to a British citizen and you walked into a British consulate, you could literally just get a passport almost on the spot. Then from 1983, it became a 2-year probationary period before you then got ILR, still faster than any other category. And then from 2000, I think it was 2012 or 2000, yeah. It then became a 5-year probationary period, so no better than any other immigration category. So it's just got more and more difficult, and now the minimum income requirement has gone from being no recourse to public funds to having 18,600, then 29,000 a year income. So the income requirement's got more and more difficult. It never gets easier, even if you look at just in terms of the costs have exponential over time. They never got any easier. And so why am I saying this? Well, what the relevance of this is, it's all about the earned settlement proposals. So in almost exactly 12 months ago today, the government published its white paper on immigration. And a lot of the focus has understandably been around ILR and the proposals to reform ILR. But actually, they did also include proposals to reform citizenship and introduce what they call earned citizenship. And they affirmed in the November paper, again, that they intended to do this once ILR was reformed. And I'll just read from that section. They said, it's been a long-standing, this is from the May white paper, May 2025 government white paper. They say, it's been a long-standing principle that citizenship in the UK, like settlement, is a privilege and not a right. We're creating a system that benefits people who respect the rules and make their contribution to the UK and take action against those who do not. And then they go on to say, similar to earned settlement, we will increase the standard qualifying period and expand the points-based system to allow those with greater contributions to qualify sooner. We will also conduct a refresh rest of the life in the UK test, probably not surprising, and consider measures to reduce financial barriers to young adults. But the reference there to greater contributions is really about, well, you would expect, given the way that the earned settlement paper went, that it is about financial contributions are going to be one of the main ways that the government is able to quantify what they consider to be contributions to in the earned settlement paper, of course, there are proposed earning thresholds. So those who earn above 50,270 taxable income in the UK will earn a 5-year discount on their period to ILR. Those earning above 125,140 taxable income in the UK will get a 7-year discount, so essentially in 3 years instead of 10. And it looks like they'll do something similar with naturalisation. What might they do? And here this is really total speculation, hopefully based on some common sense. There's currently a gap between getting ILR and getting citizenship. Why is there a gap? So you come here. I think that may have been originally that you would. So the requirement for naturalisation is that you're looking at the previous 5-year period for your absences, but also you need to wait 12 months after you got ILR. And I think the reason, in fact, that the way that originally worked was we were originally looking at a 4-year period to get ILR in most cases. I think that was changed in 2006 or so. So the typical route would be if you're married to a British citizen, you have 2 years of probationary status. After 2 years, you get ILR. After 3 years, you can apply for citizenship. If you're not married to a British citizen, you'd have 4 years probationary status, then 12 months with ILR, and then after 5 years, you'd get your citizenship. Now, because the standard qualifying period for ILR has been increased to 5 years, you've got a 6-year qualifying period for British citizenship. But why? Why make people wait this extra 12 months to get citizenship? And I was trying to think of what the reason might be, because, of course, a person moving to the UK might not want British citizenship because they might be from a country that doesn't allow dual nationality, such as Singapore. So they could be offered the option when they get to the 5-year mark of having either ILR or citizenship. So that would be a way of, that would be another way of another possible system. So what's the reason for this extra 12 months? If it's to test your commitment, ongoing commitment to the UK, though, then one would think, well, that's a period that could naturally be lengthened. So perhaps what the government would do is do something like maybe a 5-year period between ILR and citizenship, or even longer. I mean, if you look at the settlement paper, it's a radical paper. It's talking about potentially, depending on how you read it, 20 or 30 years worth of temporary status for people who arrive on small boats in the UK. So it's going way beyond the window of what was being discussed before that paper was published. And if you take that as a benchmark of not of intent with respect to citizenship, but just with respect to it's a benchmark of the radicalism of thinking, then you can expect that there will be there could well be a very long period of testing in which you are trying to establish whether a person has sufficient commitment to the UK to deserve citizenship, or as the Home Office or the government might put it. So what does all of that mean for someone making this decision now? Well, there is an opportunity cost. So yes, there's currently an opportunity cost if you have invested all of this time into and effort and money into getting ILR, which you'll lose if you emigrate and are absent from the UK. But there's going to be an even greater opportunity cost if you don't apply for citizenship now, but wait for these earned citizenship proposals to come in, because you reasonably expect that they're going to be very, they could well be extreme, and they might well cut you off from access to something that you could access now. And so that's why that's kind of the reason I thought this topic is topical, that this subject is topical, and it's definitely worth thinking about, both for individuals and for companies.
So overwhelmingly, is the advice just make an application then?
Yeah. My advice as an immigration lawyer, and I say this having done citizenship by ancestry applications for decades now, I guess. It's surprising. You never know what taking action now might mean in the future. And it's securing the best possible status that you can for yourself now, and it might be very painful and expensive and difficult to reclaim that status later on. In my own life, I remember in 2015, I think it was, that I started applying for Irish citizenship through foreign birth registration, because my father's father was born in Dublin. And I remember my family members said, why do you need to do this? This was before the referendum had been called. And it wasn't even in my mind. I just thought, well, it's always better to get as many citizenships as you can. And a year later, referendum gets called and it's out. But now I've got Irish citizenship, and so is my child. So that's very useful. That means that they have the option to work and or study in Europe, for the rest of their life, if they want to. You never know. I had a South African client, I remember, whose great-grandfather had been born in Lithuania. He had no ancestors born in the UK, but his great-grandfather had moved to the UK briefly before moving to South Africa, and had naturalised as a British subject in those days before the First World War. But that was enough for him to in the present day to get British citizenship. So you never know when it might come in handy. And I mean, there's other reasons. There's emotional, reasons, or kind of coherency reasons, I suppose you might say, that if you want your children to have the status, that the citizenship of the country that they're growing up in, and if they're going to have the status, you want to have the same status as well. It would feel weird, not strange, not to have the same status. And I mean, I think so. I suppose those are some of the reasons I would put forward. But also from the point of view of the British state, I think I said this before in connection with the dual nationality issue with ETAs and dual nationals a couple of months ago, that the holding of British citizenship by those who are connected to the UK by having lived here, the holding of British citizenship by those who live abroad, who have been connected to the UK, whether through ancestry or through residence in the past, is a part of the UK's cultural capital, international capital. And I think it's something that is more powerful than might be realised. If a government had only a focus on UK residents, a domestic focus only, I think they would be missing their total constituency. And it is actually an important part of the UK's international reach that there are British citizens living abroad. So, even if someone isn't going to live in the UK forever, I mean, the intentions requirement is typically looking at the next kind of 5 years. It's not a commitment to live in the UK forever. But it's something that I think that the government should be encouraging, society should be encouraging as a component of integration for people to get that next step and get that British passport and say, yes, I do belong to, this is a society that I belong to. And it's part of who you are. It's not a mistake that British citizenship does persist for several generations, born outside the UK, because it's a conclusion that Parliament has reached, is that we as a people include those who are born abroad, where they're linked to us in certain ways, through their parents or grandparents. So yeah, that's what I wanted to say about citizenship.
So any concluding thoughts on all of this? It's a big topic, I know.
I think I suppose said everything I wanted to say, but it's probably, just don't underestimate how much more difficult and how much more expensive it could get in the future, because we don't know who will win the next election. It can shift. I mean, immigration policy and nationality policy, it's just a question of statute. Immigration policy can be set pretty much at the discretion of whoever is in the government. So things can be made considerably more difficult, and there is talk in the Earned Settlement paper of making ILR subject to a condition of no recourse to public funds. There are other possibilities that could be done. I think it's just sensible to take the safest option is to get the citizenship. The UK permits dual nationality without restrictions. So as far as the UK is concerned, it's compatible with holding another citizenship, provided that other citizenship is also permits.
Thank you so much, Alex. That brings us to the end of today's episode. I know we've covered a lot of important issues around citizenship, and I hope you found it useful. My sincere thanks to Alex for such a comprehensive review, and thank you for listening to our immigration podcast, and we look forward to having you join us again for our next episode. Thanks, everybody.